power under Article 229,
We
Your
are not
Lordship.
dismissing on that ground. That we will do on the date when it is heard. So
Your, Your Lordships, they've been asked,
There is no-
if I may request urgent listing on the 16th, Your Lordships.
Sir, Lords.
Milords, may I mention, Milords, that Karnataka mining matter, Milords.
I'm making an, I'm
Lords.
permitted to make a mention.
Madam, we have already passed an order granting you the legal aid. Please
It has
go and
been
avail.
disobeyed, my lordship. It has been disobeyed. I am still not being provided, my lordship, since 6th of
I have
April.
already passed the order. You please go and meet the secretary. And have your cool temper. Don't misuse your dress. This I'm putting a word of caution. I'm not warning today. I'm only putting a word of caution. Don't terrorize and intimidate the staff. You have requested. I myself have passed the order granting you legal aid.
Yes, madam.
Please go and avail. With best of the ability, lawyers, we could, at least with whatever I knew, I have granted you. Please go and avail it gracefully.
My lord,
You are a member of the bar. You must respect the institution.
I am definitely respecting the institution.
Now, thank you very much.
but I'm
Go and avail.
Lordships,
relief,
I
my
request
lordship.
to
If I have my Lord's permission to mention.
I must get legal aid, my lordship. So far, I am not being granted, my lordship.
You please go and get it. I have already passed the order. Now, don't waste my time.
Milords,
Lordships,
Yes.
I request to mention that can I file 2 or 3 page written submission? I request to seek permission to file 2 or 3 page written submission in an IA in Sabrimala matter.
Sabrimala is going on, you can file it.
Oblige, Your Lordship.
May I please?
Milords, with permission, Milords,
Lordship,
may I
if you-
mention?
My lords, I am troubling my lords today.
Coming up on day after tomorrow, my lord, on 15 pertaining to Kaveri water dispute, my lord. We have moved an application for open hearing, open court hearing, my lord. Lordship may kindly consider. This matter is of some importance. In an MA, my lord, an order was passed. Virtually, my lord, giving direction contrary to the main judgment which was rendered in 2018, my lord. That's why we are making a request for open court hearing.
No, review, is it a review?
Review, my lord, review. But
See whether it is to add in open court.
Please.
we have made an application, my lord. It goes beyond the main
No,
judgment.
that,
Milords,
My lords, this is a matter for Wednesday, and it's before Justice Narasimha. Unfortunately, he's not there today. My lords, it is a contempt.
Bench?
Justice Narasimha.
Oh,
My lords,
it's only for today.
my lords, no. My lords, there's a fresh contempt that was filed a week ago. Unfortunately, even the defects have not been able to be listed. It's very important and it's urgent. And we just want it listed on Wednesday.
Urgency, madam.
I beg your pardon?
Contempt, what is the urgency?
My lords, the urgency is this. My lords, may I explain? This is a recruitment matter in which Justice Narasimha himself had passed a very, very strong order in my favor. Now, the seats, it has come to my knowledge, have been filled at such a fast rate that quite soon I will, essentially be non-suited despite.
Don't want anything on merits. Please tell what do you want now?
I just want it listed, my lord, subject to the my colleagues clearing the defects.
Day after, on Wednesday, Justice Narasimha will be here. You can make a mention before your lordship.
But if it's listed, then I can argue it on that day, my lords.
We will see what can be done.
With your
My lords,
lordship's kind.
I'd be grateful. I'd
Lordship,
be grateful, my
If
lord.
I have my Lord's.
May I mention a fresh matter?
My lords are allowing.
Will be preferred by
My
the
lords
state.
are allowing it.
We have not allowed or disallowed both.
All right. Okay.
Lordship,
Milords, may I?
Lordship, the
may I be
SLP
permitted to
preferred by the
mention
state
Karnataka
yesterday,
mining matter,
Lordship,
Milords?
against the grant of anticipatory bail, Lordship. There's some urgency, Lordship, in the matter. Lordship, I'm praying that if Lordships could grant of anticipatory bail, the state has come, Lordship. The state has come by, it's been passed by court, Lordship, according to us, without territorial jurisdiction at all, Lordship. Lordship, we are only praying that Lordship may hear it on Wednesday.
We will examine. We will
Please, Milords, may I mention?
Obliged.
Milords, the Karnataka mining matter, Milords, Samaj Parivartan, Milords, we
Milords,
had
I
mentioned it in
wish to say-
January. Milords, there are,
get for the turn. Every matter is important.
Milords, may I only pray for some date that may be.
We can't promise anything. You know it, question bench is going on. After that, we will see what is to be done.
If I have my Lord's permission to mention urgent oil and gas.
Obliged.
What has happened in Bihar is, Lord, the Municipal Corporation Act has been amended to actually disempower, Lord, the mayor from choosing his empowered committee.
So what?
I challenged it, Lord, that was there was no interim order.
Challenge before the High Court first. Very good.
That order I appealed before your Lordship. I have taken out
High
that.
Court has, why High Court has adjourned for Monday, therefore Supreme Court. Why it have listed on Friday, therefore Supreme Court. Only notice have been issued, everything is being checked.
One more line, Lord. I listed that, Lord.
Save the jurisdiction of this court for important matters.
I just say one more line, they have directed that the empowered committees be appointed between 15th and 20th, and that's what.
Whatever they have done,
Lordship, my lord.
the High Court must have applied its mind. We are not sitting here like every day, keep on monitoring on with the radar and what's happening there.
Directed, my lord. This is a direction of the ground.
Thank you very much, thank you, no.
My lords, if I have my permission to mention an urgent oil and gas tender matter, my lords, in this case, the financial bid has already opened, my lords, and the respondent may grant the letter of award any moment, my lords. Oil and gas tender matter, my lords. The financial bid has already opened, my lords. The letter of award may be granted any time. I'm requesting urgent listing, my lords.
What's the urgency in it? If you
Malas,
size, we will come.
My lords, the bid has already opened, my lords.
All right, it's all right. All early hearings are rejected. Now start.
With your lordship's permission.
Wasting time. We have already told you within 2 days matter will be listed. What is the great hurry? Thank you. Thank you very much. Item 11. Let it be remain a difficulty, but you can't do anything.
With your lordship's permission, may I mention a matter? My lords, it's a leave granted matter. My lords may give a fixed date. The respondent number 1 is 80 years old and suffers from several.
We will see what is to be done. No promise. Thank you.
My lord, the other.
Item 11.
In item 11, I'm requesting a short pass over, my lords.
What is password issue notice? Issue notice.
Patient, my lords.
Item 12.
Application.
Please wait. Millards, we have sought declaration of section 2, 3, 4 and 8A of the Dowry Prohibition Act, section 2 and 3 of Protection of Women from the Domestic Violence Act, section 498A of IPC, and section 12(1)(c) of Hindu Marriage Act as.
The only mistake committed is that last time some exemplary course should have been imposed.
Millards, may I say that? Millards, may I say that? Millards, the decision has not been made on merits. There was no effective hearing in that matter. Millards, under Article 2 of International
How
Covenant.
the office is entertaining the registry? When the matter has been dismissed already.
Millards, it's an illegal dismissal. It is in violation of Article
What
1
do you
and.
mean by dismissal?
Millards.
Be then honorable.
No, Millards, there are no, it's by a non-speaking order.
And you are the same petitioner.
But Millards, it was by a non-speaking order.
What do you mean by
Justice has not been done, Millards. Millards, people have a right to justice and Article 2 is violated. Millards, Article 2 of International Covenant on International Civil and.
The petitioner had earlier filed a petition civil number 68/2025 seeking identical relief. The coordinate bench headed by the then Honorable Chief Justice dismissed that petition on 3rd February 2025. A coordinate bench, a coordinate bench of this court dismissed that petition on 3rd February 2025. The instant petition from a perpetually in public interest has been filed, claiming that the earlier petition was dismissed by a non-speaking order. We find the argument totally frivolous and uncalled for. While dismissing the petition, the petitioner is cautioned in case he indulge in filing such kind of petition in future, there shall be exemplary costs imposed on.
Millards, may I mention? Millards, may I also
Don't
mention?
waste our time, please.
People's rights have been.
Next item.
Yeah. Now, my lords, here there are two cases on your lordship's cause list today. My lords, one is serial number 13 and the other is serial number 49. Now, sorry, I'll just explain it to you, my lords. As far as 49 is concerned, it's a writ petition in which your lordships have already issued notice, 49. Now, on that, at midnight or something, we have been served with a reply.
We have filed a status report.
All right, I haven't even seen it.
It's a status report which the high-powered committee has filed, my lords.
in response to the writ petition which they have filed, item 49. That
Yeah.
unfortunately could not be filed earlier. We filed it yesterday night. So that's not on record.
You have filed your reply to them.
I'm appearing for the high powered committee. So
But
we have
you have filed reply to them.
a status report because it's not adversarial according to us.
That's right.
Yes,
That's
we
not
have filed a status report dealing with all the submissions which they have made in the writ petition.
Yes, so that is that has come at very late at night, so we haven't had a chance to study it. So I am just suggesting to the court that as far as serial number 49, on which your lordships have issued notice and on which they say that they have submitted, your lordship may call out the matter after 2 weeks is my request, and thereafter, my lord, we'll respond. Now on that. Yes, on that aspect, I should also tell the court, I will have a note which I will.
Counter affidavit is in writ petition
Not a
744.
counter, my lord.
It's a status report in writ petition in 1228 of 2025.
1228. That's a separate petition.
Why is it 20?
Now, may I also make a suggestion with regard to serial number 13 on the court. Now, 13 is an MA where again I have some suggestions and there appear to be certain factual errors which have occurred in the order. So, in the original order. So on that, I have a note which I will share with my learned friends because certain historical facts, we don't want those historical facts, if they are inaccurate, to remain in the court's order. So I am just suggesting to the court, since your lordship is putting for.
Adjudicated any historical.
No, you're right, absolutely right. But
That some passing reference.
that's right. So I'll just broadly tell you what is. Sorry. Yes. Number 13, I have a note which has what your lordships have recorded and what our suggestions is. If I may be permitted to just give an advance copy to them.
You can give an advance copy.
I'll give them an advance copy.
Also,
Yeah, because we don't want an inaccurate reflection here because we found that some things may not be supported by the pleading.
Tentatively, we are not proposing and we might not be inclined to make any structural change in the arrangement.
Yeah.
Yeah,
there'll be some small suggestions, yes, but the factual errors can go. So on that, Manoj, may I request that matter also to come along with whatever date. Both the cases can come together.
Item 49.
May I point, as a high-powered committee appointed by the Honorable Court, just we want to go by whatever the direction the Honorable Court issues in this particular matter, we want to go according to the direction of the Honorable Court. We do not want to take any adversarial stand in the particular matter, number one.
No,
Number two,
that's
if they,
yes,
yes,
as such, because basically idea was that some development must take place there.
correct.
Such historical temples.
Yes. Number two, whatever the facts or suggestions he wants to give it, he can give it on facts. We will place it before the Honorable Court for the consideration.
Going into the pockets of some families only.
Yes.
There was no such thing, Manoj. There was no such thing. Anyway, we'll satisfy your lordship. But on both, I will submit a note right away. I'll just share the note on both aspects, and then your lordships can call it out after 2 weeks. Is my request.
Item 49 it is stated by Mr. Shan Thakur once presenting the high-powered what is it called? High-powered management
High-powered committee.
High-powered committee. Management committee. that counter affidavit was filed, has already been filed.
Says status, he says status report.
It's a status report according.
Okay, a status report has been filed, you're saying is not on record. Registry directed to tag the same with the paper book. A copy there will be supplied to the council for the petitioner. Post this matter on so and so date after 2
Yeah,
days.
Manoj, my response within 1 week to the status.
The response to the status report, comma, if any, may be filed within 1 week. Then item 13 may issue notice. Then transfer assisting counsel and Mr. Nataraj, you are for the state.
No, I'm for the High Power Committee along with Mr. Sharan Thakur. Both of us were there.
Say, so Sri M. Nataraj from PSC and Sri Sharan Thakur and senior counsel representing the High Power Management Committee. Or 1960 council and Richard Aguel, they seek and granted 2 weeks time to file their reply to the MA. Post both, this and this item 13 and 49 both from council.
I'm so.
There is some date being indicated.
Well, we'll list the date, we'll give a date because
I'm grateful.
I have to see about that.
Very well. There's just Manoj, 1 or 2 dates which I will just request the court master not to give. Other than that, everything is fine. I'm grateful. I'll share the note.
If I may give over the physical copies because they have physical copies of the SPINI file, but physical copies have the color photograph. If I may hand that over of our status report because they're all the color photographs of that and the e-copy doesn't.
Find it.
We'll find it physically.
I'm grateful, man.
That is
Grateful.
Yes, Your Honor, the matter kindly be tagged with the ongoing cluster.
There are other matters pending on this issue.
Yes.
Issue notice, return.
Obliged, sir.
Is there any date in those matters? Is there any date in other cases?
Yes, I think it is listed on 20th. I don't confirm.
Anyway, 13th. Issue notice returnable on 13 May 2026. Tag will soon.
My lord,
Are you accepting notice?
on behalf of state of Rajasthan, ma'am.
For state of Rajasthan?
Very well, ma'am.
Accept notice on behalf of state of Rajasthan. Let the soft copy as well as hard copy of the written be handed over to Land State Council. The counter affidavit can be filed,
Very well, ma'am.
preferably before the next date of hearing, 13th May.
Very well. Deeply obliged, ma'am.
Item 15.
Lordship, this matter pertains to 2 major issues. First is regarding enforceability of pre-primary education, which is not mandatory till date, sir. And second is regarding implementation of.
Would like to know.
Lordship. Second is regarding implementation of Right to Education Act and National Education Policy 2020.
We are issuing notice, sir. We are issuing. We would like to examine. Issue notice.
Thank you. Highly obliged.
My lord, I am seeking short passover, my lord. Lord, I am seeking short passover, my lord. My lord, Mr. Nachiketa Joshi is appearing, senior advocate. Nachiketa Joshi, senior advocate is appearing, my lord.
Pass it.
I'm seeking a short passover. Short passover minutes. The council has to.
Where in this now in this matter?
He is on his legs to.
Don't file this kind of petitions. You have been doing a good job.
Yes.
And we have appreciated, we have done whatever we could do. But as far as this is concerned, the parliamentary prerogative and it is already being taken up.
Very short.
Can I submit your lordship with permission? Can I submit your lordship? Lordship, connected matter is already notice issued and pending for court number 4 in writ petition number 1092 of 25 lordship. Court number 4 it is pending right now. Same with Dr. Jaya Thakur and all your lordship. It can be both can be heard together, your lordship.
No, this court will now enforce the provision which is under, and Parliament is already seized of the matter there, and it's every day it is being reported. Today is also
Similar to the same issue, notice already issued, one court is hearing, Your Lordship. Both can be heard together. Otherwise, Lordship can call back that matter to hear and can be heard together. Notice issued, same thing, Your Lordship.
No, which petition are you referring to?
There is another petition in court.
It can be sent to that court or call back to Your Lordship.
Parliament is
I will address on that issue, Your Lordship. I will come and address on that issue. Otherwise, Your Lordship, my pastor will come and. Petition number 109 to 2025, Your Lordship.
This data put was withdrawn. You want to help this? See, you put it over. Yeah. The case is not like this. You love total pressure. Stay to be lost. Those two negligence. You will think you deliberately without schools.
Bill 2025, along with this resolution, list one should do.
Greatly obliged.
Your Lordship, arguing counsel is through VC. Arguing counsel is through VC, item 18.
May I please, Your Lordship? May I please, Your Lordship?
Yes, please.
Am I audible, my lord? Am I audible, my lord?
Yes, please. We can hear you. You are audible.
My lord, this matter raises a substantial question of law, in a sense that a person who is occupying a office of the council member in the Chakma Autonomous District Council simultaneously is occupying the post of office of the member of Legislative Assembly in the state of Mizoram. We challenged it. That amendment which was been brought in the year 2003 is per se manifestly arbitrary. The Honorable High Court said that we cannot read into the statute and there is no corollary provision in the 6th schedule or under Article 190 and 191. So this matter is not made out. Per se, I say that this, Your Lordship has held in Pumi Laik's case in Mizoram, that the 6th schedule is a constitution, is a part of the constitution. It cannot be treated as a constitution within the constitution. So this judgment per se is illegal. Let me demonstrate here, Your Lordship. Kindly come to the additional document which has been filed at page 17.
Yes.
Your Lordship will find that page 17, vacation of seats. This was prior to the amendment. Kindly see subsection 1 of 11. My lord is there? Page 17.
Probably the only argument you should have raised before the High Court was that
My lord.
there is it's a case of complete, or maybe, ultimately whether it was made out or not, that was subject matter of argument. But the only argument possibly you could raise was that in the case of Lai district autonomic, this council,
Autonomous Council.
there is a
There,
express bar in holding the dual position.
my
But in
lord.
the case of Chakma council, there is an exemption. Therefore, this classification is not based upon any intelligible criteria. You are
My lord,
argument of holding the office of profit fails because division bench holds against you. That
My lord,
argument was earlier rejected. Now
your
your
lordship,
argument are based upon Article 101 and 190. Again, High Court's view is correct, but the other argument unfortunately never raised.
my lord, your lordship will appreciate that as far as the office of profit is there, I have conceded that I am not arguing in that office of profit. Kindly come to my kindly come to the SLP.
Just wait. From the impugned judgment of the High Court, it seems that there is a bar on dual membership in the case of Lai Autonomous District Council members, but no such bar has been prescribed for Chakma and Mara. Not only that, the earlier bar had the bar against this the bar and the express bar in respect of these two district councils has been to notice.
Obliged. So this is a very important petition. "19, my lord, is a very important petition for the farmers of this country. There are two problems as a result of which, my lord, more than 10,000 farmers every year are committing suicides. One problem is that the MSP that is being fixed by the government is below the actual cost price, which is called C2. Of course, Swaminathan Commission said C2 plus 50%. That was the recommendation, that the MSP should be C2 plus 50%. But here, the MSP that is being fixed is below even C2, forget 50%. Secondly, the procurement of most crops, even at the MSP fixed by the government, is not taking place. Only for wheat and rice, it is significant, is about 35% or so of wheat and rice is being procured by the government at MSP. But for the rest of the crops, it is sometimes 2%, 5%, 10%, etc. So the farmers are in acute distress in this country as a result of this situation, this twin hammering, my lord, as I call it. Firstly, the
lot of mathematical formulas that you are.
Yes.
If these formulas are applied, probably they will start disowning the responsibility of MSP. That is one. But what I'm visualizing,
I'm not even campaigning for, I'm not asking for actual cost plus 50%. I'm not saying that. The actual cost is called C2, which includes all the costs. And that, if you take the weighted average cost of production of a particular crop, let's say, my lord, wheat, take the weighted average cost in the country, that includes all the costs.
difficulty will arise only in respect of the cost of land and capital.
Yes, but that the government itself calculates. In fact, my lord, if your lordship sees, there is a chart.
Because of that, will it not vary from now state to state, and even it can vary even from district to district?
So the government and the government's own institutions Hmm. The government's own these calculations are made. These calculations are made by the government itself, and that this is the weighted average. I'm not saying that in some place where the cost is very high, they should pay that cost. Not at all. What I'm saying is government's own calculation of weighted average cost in the whole country, which is called C2 for the whole country, at least that much should be paid.
So Bhushan, you are almost asking us to rewrite the economic policy.
No, no, it's not.
You are going to the extent of saying that because there is free ration made available
Yes.
on the basis of procurement of rice and wheat,
Yes.
our opportunity of getting higher prices on the free market for these commodities is being destroyed.
Yes.
So do away with the free ration, give them direct benefit transfer.
Not at all, not at all.
No, this is a part of your pleading.
No, 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 that's not, Lord. I have been misunderstood then.
No, your pleading is there. You know,
Maybe, Lord, my junior had drafted it.
So
Maybe,
you may say
maybe
that
not
I am not
exactly.
pressing that portion of the.
No, what I am saying is this. It is absolutely fine for the government to give ration virtually free. Perfectly fine. It is required in this country.
Yeah,
but, my Lord, that should not mean that the effect on the farmers is such that they do not even get their cost, as a result of which, my Lord, they are committing suicides. So therefore, and I am not saying that you give those farmers in those states where the cost is high. I am not saying that.
That at least this way of calculation,
Yes.
at least somebody should have pointed out to the government, some stakeholders should have been first pointed out that, look here, we should do like this.
No, government itself has done it. See page 394. See page 394. This is the government's own Economic Statistics and Evaluation Division of the Department of Agriculture and Family Welfare. 394, my lord, of the petition. Soya bean. This is one example. Now, if your lordship sees everything is there, cost of cultivation, A1, A2, etc., 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 and then it comes to C2. Now, C2 is the final cost, which includes everything, including the cost of family, imputed cost of family labor plus cost of different. I am deeply obliged, Lord. This is a very important petition. I know, Lord, I don't want a situation where people who do inefficient farming or in states where the cost of production is high, that they should also be paid their cost. I am not saying that. I am saying take the weighted average cost of the whole country. Weighted average cost of the whole country, at least pay them their cost.
One day, second day, again, some issue will have to be determined. You can't have probably a uniform policy for all sizes of farmers. There are big landowners who have big chunk of land.
You can have a policy where you say, don't procure from those farmers who are large farmers. You can say that. So there are two prayers, my lord. One is procurement. That at least procure on that MSP. You are not even procuring 5%, 10% you are procuring. And number two, my lord, fix an MSP which at least takes care of their actual cost, weighted average cost. That's all. I am obliged.
Rosen, item 20, the main set of cases is coming up on the 13th of May 2026. Now, there's just one or two dimensions that we want to just project over here, if your lordships considers it appropriate. I have moved an application for implement of just one state of Rajasthan, and because that's where primary work of the petitioner has taken place. And the second is just, we are requesting also notice on interim relief. Let me just explain it before we get down to it. I have handed in a note, which your lordships will just see.
Interim relief maybe, but in any case, we have issued notice in.
I'm grateful, but I'll just tell you what the interim relief is about, so that you needn't even turn to it. What is happening is that as a consequence, we don't want a stay of any impugned provision, etc. What is happening, if your lordship goes to the third page, which folds out, is that because of the masking of data and individual data sets, work which is actually going on in the field and work which can be done on the field and on the ground, because it's available, the information is available and it is linked to individuals, may be impaired. So the interim relief which we are, if your lordship is pleased to issue notice, is only that don't please delete data, because that deletion or masking of data will cause problems. Now, my lords, we've just given 3 illustrations. May I just take you to that last page of the note which is handed in? Please just have a look at that. Please just see this. 3,729 pensions were abruptly stopped in the Bhim block. Around 1,000 living persons were declared as dead and without notice. This is, my lords, pertaining to the year 2015-16. We've given an example, a separate example for 16-17 and 21-22. Now, MKSS volunteers obtained the stopped pension list under the RTI disclosure mechanism, containing names, ages, addresses, pension type, and reasons for cancellation. Thereafter, we engaged in a door-to-door verification of the beneficiaries, which revealed that 400 of the so-called dead persons were in fact alive. MKSS obtained the itemized stock pension list containing names, ages, addresses, pension type, and cancellation details. That named list enabled verification. Now, as a result of this, my lords, the verification and restoration was carried out. Now, this was only possible because those individual names were available and door-to-door verification could take place. This may be impaired. Now, see the second example. Siphoning, this was an example of siphoning of grain from PDS in Thana, Thana Bhilwara. Ration dealers were under-delivering the grain. However, official records spoke otherwise. MKSS volunteers obtained delivery information from the Jan Suchna portal, which includes, and then there is a bunch of information which was there, which was individually available. Now, please go to the next column. The information was projected on a screen during village gatherings, which enabled verification of official records with individuals' lived experiences. This collective verification revealed that over 5,300 kg of wheat had been siphoned off by the ration dealers, etc. Now, this exercise can be done house to house, door to door, on the basis of that information, which is presently being put up on the Jan portal. So it's presently available on the portal. We are apprehending, if your lordship sees the third example, which is securing relief for silicosis victims. The compensation for silicosis patients was delayed for years, leaving several of them in despair. With the efforts of civil society organizations, the victim level data was disclosed through the Rajasthan silicosis portal, containing the identifying information, application status, reasons for delay, and officials responsible. MKSS volunteers use this information to pursue individual claims with concerned officials to facilitate expeditious release of compensation. Now, the problem is that this is how compensation was actually revealed. But if this information is taken off or masked, so information is up there just now because this act, the provisions have come. But the apprehension is, because in certain states that was shown to me as well, the masking has started. So interim relief, if your lordship considers it appropriate, may be that please, whatever information is available just now on the portal, don't delete it until, or don't make it unavailable.
Even if it is, of course, we'll issue notice. We are issuing notice because already matters are pending. This information in any case can't be destroyed. This information will.
It's so
data has been
beneficial.
gathered.
Yes. It's so beneficial, and it's only with respect to these public, where there is some government subsidy or where there is government help which is there, but it is not reaching, it is siphoned off, etc. So this petitioner before your lordship is a voluntary organization which has done huge work on the ground. So therefore, I'm requesting also, my lords, on the, I've just handed in an interim application. Notice may be issued on that as well. We'll file it.
Okay. Date is no matter. 13th May.
They should take the application and reports.
Yeah.
Notice in May also. Okay. That is one.
Well, state of Rajasthan implement may be allowed.
Oh, that is. This one, and this one to allow. State of Rajasthan to, specifically apart from this one, to go to implement. Notice issue to the newly added respondent also returnable on some city.
I'm grateful. Your lordship has issued notice on that.
Yeah,
I'm
yeah.
very good. Okay. Huh?
May it please, Millets. In the Bar Council, Millets, my lords wanted to empower the women, but some are trying to misread that directive of your lordships virtually to weaken them.
But is there any order passed by the, empowered?
High Power Committee, Millets?
Page 45.
Yes, Millets, my lords could see. That's at page number 41.
No, Justice India's committee.
Yes, Millets. At page 41. Kindly come to page 47 Millets, where the directions, in the light of your lordships, the direction earlier given, the committee has formulated certain policy.
Para 20.
Indeed, Millets, para 20, what's material is clause D in that para 20. The rest talks about various nuances of that one, if more women contested, fewer women contested, or no women contested. What's relevant for the purpose as far as Andhra Pradesh and Telangana are concerned, Millets, many women have contested. In both cases, more than 30. In one instance, 55. In one instance, one woman got elected on her own strength. The remaining, they have contested. They have got fewer votes comparatively. My lords may kindly see Millets, D. If there are more than 5 women candidates, then counting shall be done in the regular normal manner, except that eliminated women candidate would be placed in a separate list category.
But in D, if there are more than 5 candidates.
Yes, Millets, para D. If there are more than 5 women candidates, then counting shall be done in the regular normal manner, except that eliminated women candidates would be placed in a separate list category or in the reverse order of elimination. That is, the last eliminated women candidate would be placed at serial number 1 and second last eliminated women candidate at serial number 2 and so on. Counting would continue till the requisite number of candidates after deducting the number of women candidates to be elected to the extent of 20% seats reserved for them or declared elected. In case any women candidates are elected in the normal course, the regular and normal process of election would be extended further by adding such a number of women candidates to the list of candidates to be elected in the normal course. The only grievance that we could ventilate with your lordships vis-a-vis this and also Bar Council amended Rule 3 is that, Millets, my lords intended that there should be sufficient representation for the women. And your lordships have felt that 30% should be there. And my lords have also felt that many women will feel shy of just contesting. In that event, your lordships have said if somebody contested, 20% you draw from them and 10% you can co-opt. And now, Millets, on the converse, what has happened, many women have contested and they have come very close sometimes or otherwise. In that case, Millets, the only prayer that could be is this, Millets, that from among the list as has been indicated, let all 30% be selected. Otherwise, Millets, what's been indicated in Rule 3 is that, Millets, all the bar associations across the state will recommend names. From that, they choose twice the number of candidates, that's 4 candidates. It's a mayhem.
Let us see what Justice India is saying.
Yes. This is what their lordship, the committee has said, Millets. And my lord's order could be seen, which has been explicit. That could be seen, Miller's order dated 8/12/2025 at page 29. That's the fountain for this provision.
No, but this paragraph only deals with the situation where Justice Dhulia has said that if there are more than 5 candidates.
Yes.
And out of them, say, let us say 2 women candidates get votes more than even male candidates. Then it is like in the reservation, let us say service jurisprudence has been applied.
Yes.
If you are a reserve category candidate and you are higher in merit than the open category, then you are to be treated as open category. That is what the same principle, that if the women candidates get votes more than the male candidates, they will be adjusted in the general category and there will be a separate list of.
That's not been applied.
All the women got less than all the men.
Yes.
Number of votes.
Yes, Telangana.
Telangana. In Andhra, they got.
Telangana. I'm only voting you for Telangana. I'm the guy who got the most number of votes.
I know, my friend.
Yeah.
Yes. 30. 30 means I got direction. Supreme Court.
That's correct. Your lordship's order, in fact, would have bound Justice Dhulia's committee.
That is what Justice Dhulia has indicated in
Correct.
paragraph 2, page 42.
Correct. So the reason why we are here,
What actually the applicants went there
yes,
were for separate ballots.
that's separate ballot. That's anyway not an issue.
Dhulia explains that it's a single transferable vote.
Absolutely.
Separate ballot will become cumbersome.
Correct.
Keep it in the same ballot, but the indication of gender should be there.
Exactly.
So far as
Yes.
women candidate.
No, so
is
if I
what-
may-
As far as
They also gave a very illustrative example of how you are going to count
So
it.
may I just clarify one small thing? Because I am the person who got the number one most number votes in Telangana. Man, all the men got, because of the numbers, more votes than the women. But I'm supporting the claim of the women candidates who stood and came 6th and 7th because 30%.
Not endangered.
No, not because of that. I think the fairness demands. Fairness demands that where 52 of my bar members have come and taken part in the elections, and there are substantial number of them, and 7 have to be selected. Now, because of your lordship's order, only 5 can come through elections and 2 by way of co-option. It was supposed to be a one-off, and that happened because of the submission made on behalf of.
Gopal,
Yes.
when we passed this order,
Yes.
we had a pan-India view in mind.
Correct.
yes,
No,
exactly.
fair
That's at page 30. My lords could see your lordship's order.
It's very encouraging. and
Yes.
We were not there. It was more a concessional order, so to say.
Millets, now what happens in this case?
Understand the
Yes.
applications are very high.
The unintended consequence of this is that, Millets, those who contest, who took the trouble, now they've been marginalized. Those who don't,
Democratic process.
yes,
Anything else?
yes.
The election is democratic.
Only in the absence of candidates,
We have to
that co-option should be there.
democratic potential.
Yes.
Free exercise.
Correct. That's all.
But nonetheless, election process already started and.
No, so
It's only,
Earlier order, we have.
No, so in fact, your lordship's
That's not-
order was in the light of the Bar Council of India telling you that 4 states had notified. Unfortunately, it was not pointed out to
was
you
not.
that Telangana, which is one of those states, had not been notified.
both states, Andhra and
Subsequently,
Telangana.
You modified it. But when your lordships modified it, it was still not brought to your notice that you have this many candidates. Now what has happened is the Bar Council of India, and let me tell you candidly, this has been a problem even earlier. The Bar Council of India comes out with rules in February saying we are doing a one-off co-option. We will do the co-option, Bar Council of India. And they will co-opt for my association 2 people after consulting with bar associations of the
1,000 bar associations. And it opens a Pandora's box of having many candidates contesting why only a few have been preferred.
Mr. Gopal.
Yes.
That it's a kind of an understanding or a uncontested commitment in that process that we persuaded Bar Council of India, 20% by election,
Correct.
10% by co-option.
Correct.
Now that rule this year we will not deviate. Number one. The only issue probably which directly you want to raise and you are yet to point out is that what should be the manner of co-option?
If
May I say,
if we can prevail on your lordships to consider that in those states where there are enough women candidates, please follow the democratic process.
well,
Exactly as
either
Justice
way,
Bhag-
either way,
if they
let me
are,
just put it this
if there
way.
aren't, then obviously your lordships.
Either way, either co-option or directly taken, the men have to make way for them, those 5 + 2, 7 candidates. And they have to be taken instead of going for co-option and going across 1,000 bar associations and they're sending the names and some to be picked up. All others will be up in arms saying that why somebody has been picked up instead of me. Because I say that I have my credentials as good as anybody else. To avoid that one, my lords, if my lords could zero in on the candidates who have contested their sufficient number, based on the rank as has been indicated by the high-powered committee, they could be there.
Again,
Either way, it is the women that have to come.
Can I just say one line? The Advocates Act.
But again, you are not picking up the right point. You probably only want to say that co-option should be from among those who have
Manoj, we are
contested.
trying to persuade you to accept the first one. Otherwise, we'll fall back on the second. But the first one, just give me a minute. Section 3, subsection 2B of the Advocates Act makes it clear that in the case of a state bar council with an electorate exceeding 10,000, 25 members elected in accordance with the system of proportional representation by single transferable vote. Now, because we want to accommodate the women, your lordships in the right spirit said that if we don't have enough candidates, then what do? But bringing in by co-option is only in an exceptional situation where you don't have.
When they spoke enough candidate,
Yes.
we understood enough successful candidate, not enough contesting candidate. Let us say you were
Yes.
indicating to us
Yes.
a corpus of contesting candidate.
Yes.
Out of that,
Yes.
maybe more than 20% are contesting.
Yes.
But the successful candidate,
Yes.
there may be only 5%.
Yes.
Women.
Yes.
In this situation,
Yes.
what does
No, but
How
the
then
minute,
the
the
co-option-
minute your
Then
lordship
the co-option will be among the contested candidates.
don't give a carte blanche to the bar.
Millets, what happens otherwise?
Go for those contesting candidates.
Yes,
and from
because
that
they've
pool
proved
of
their
contesting-
credentials. Otherwise, what happens, Millets? Somebody who has contested, taking all the pains. Yes, ma'am.
No, maybe, and now I'm getting what fell from the Chief Justice. Allow me the allowance of not being as wise. Well, then, if these contesting candidates, if the permission is given to co-opt from
Among them.
it could accommodate 6 and 7. Ideally, my lords, because there's a one-off situation.
It's more a middle path.
I understand. Ideally, if your lordships could consider the relaxation, but other states will also come to you with the same plea, and your lordship will have to repeat what you've repeated today.
There has to be
Yes.
a uniform criteria on all the.
That it has to be. It has to be.
It will create complications.
It has to be. Yes.
Now, if possibly it can be one of the fair criteria that suppose there are, let us say on hypothetical basis, that 3 women are to be taken in one state
In
bar,
a state. Yes.
and 3 who got the highest number of votes
Yes.
have been picked up,
Yes.
and they are there. Now, 2 more are, let us say, to be co-opted. One way is that the bar council, like they have uniformly decided that they will decide that who should be co-opted.
Yes.
The other way can be, you may argue, no, the next 2 are in order of voting, number 4 and 5.
Yes.
They should be co-opted because at least they have some
Yes,
representation
that's
behind
Mr.
them.
Naidu's plea. Yes.
Maybe some other transparent criteria can also be there. So let us first request Justice Dhulia to examine this aspect because they have got feedback from all India.
Very well.
Isn't it, Joy?
We have already given our representations as well, Millets.
Only thing, sir,
We will
right?
That's true. That'll be.
ये paragraph 2 में पुलिया सब लिखते हैं.
If para D can be taken its logical conclusion and remove cap 20%, that suffices.
Problem is because at para 3, the chairman's statement is that liberty may be given to the Bar Council to fill up posts by co-opting women in the current election. It's 5 years. So 5 years, whoever they handpick, it could not have been.
We
Yes.
wish to revisit the
Yes.
pool from which co-option is.
Yes, my lords.
Exactly.
Either the contested candidates or lobbying candidates.
No, and
It
also,
could be either way.
also,
One uses his exertion
yes,
and availability and popularity in the bar
yes,
to contest, but does not make the mark of 20%,
yes.
may be the pool from which the co-option may be considered.
In this
If
one,
the contested candidates pool is there, it's an incentive, even for the future, for them to come and do that one.
but I have one second suggestion. One is about the pool. The second is who will do the co-option. Surely, I don't know if that was your lordship's understand that you will have the Bar Council of India do this co-option for every state. Candidly, my lord, the problem has been the Bar Council of India. The fact that they handpick committees who run these associations for 15, 16 years.
Out can be, we impress the power of co-option to this Dulia's committee. And we, of course, will have to leave to them, to their wisdom, that what transparent criteria.
They are actually.
No, here is the, come. These are the committees.
Mr. Giri.
Ravi Shankar Jha. And Dhuri.
This seems okay.
I don't know.
Let them take a call on it.
Right.
Committee takes a decision.
It can.
My own, but
for whom?
My lords, I am for Bar Council of Telangana.
Bar Council of Telangana.
one suggestion is that this committee may associate, because the Advocate General of each state or the ASG is a nominee who is ex officio a member of that respective Bar Council. Like in the Bar Council of India, it's the AG and the SG. So similarly, when this selection is being made, co-option is being made, the committee may associate the Advocate General. Just a suggestion from me. It's not from any of the clients.
Either way, my lords may authorize the committee to decide on this issue, allow us to represent before them, because we have already made our representations.
Start coming.
Yes.
Therefore, we need to pass this order.
Correct.
Precisely.
very early.
Yes.
So today, because we are not touching merits as such, so we are only asking, requesting Justice Sudhanshu Dulia's committee to take a view.
Yes, my lords. And please allow us to represent before the committee.
And my suggestion for Advocate General is only that local knowledge of who these people are will.
That suggestion before.
Very well.
We will ask Justice Dulia's committee to
Consider.
consider the different viewpoints and then take.
Yes.
But in the meanwhile, there is the elections which have to take place to the executive committee. They have to elect the president, the vice president, and there has to be a member who they will nominate for the Bar Council of India. So it will either be done before or after, as your lordships consider.
A week or 10 days, if things could be put on hold, it can be decided.
It is to be done.
It has to be done when? By when?
My lords, 9 states issue is pending, my lords.
It will take time, I think.
It's supposed to be done by January 30. But
It will take time.
it will.
So this court-wide order dated 8th December 2025 for an exercise of powers under Article 142 of the Constitution ensured 30% representation for women candidates in each of the state bar council. Out of these, 10% were fulfilled by way of co-option and 20% by way of election. The operative part of the order to this effect reads as follows, para 6 of it. Next paragraph. This court also appointed the high-powered election supervisory committee headed by Justice Sudhanshu Dhulia, former judge of this court, along with two members, namely Justice Ravi Shankar Jha, former Chief Justice Punjab and Haryana High Court, and Mr. V. Green, and senior advocate from Supreme Court of India. The state election committees were also constituted. Next, at the outset, we acknowledge the commendable Herculean task which the high-powered election supervisory committee has been performing since the date of its constitution. In that process, the supervisory committee has passed a self-briefing order dated 9th February 2026. With a view to clarify as to how the direction issued by this court read 20% by election and 10% by auction for women representation, is to be given effect. In this regard, the supervisory committee has clarified as follows: para 20, page 47 and 48. ABCD. We need more. Next paragraph.
Can it be passed over?
We are informed that meanwhile, the Bar Council of India has issued a circular that the selection of candidates for 10% co-option shall be made by the Bar Council.
Rules. They have issued rules on 18th February 2026.
Inserted a rule which inter alia provides that the selection of candidates for 10% co-option shall be made by the Bar Council of India.
At page 55.
Next paragraph. The lack of clarity in the order of this court as to what will be the mode and manner of 10% co-option is the essential cause of action giving rise to the present proceedings. Next paragraph. It is thus before us that in states like Telangana, more than 5 candidates, women candidates.
Well, it's both Andhra Pradesh and Telangana. Both Andhra Pradesh and Telangana. The first matter is in fact from Andhra Pradesh. Both are identically placed.
In various states like Telangana, Andhra Pradesh and Telangana, more than 5 women candidates contested the election, and some of them have been elected against the open seats
In Andhra Pradesh.
from having secured votes more than their male counterparts.
In one case, one candidate.
One candidate in Andhra, not in Telangana. Just want to clarify.
And there are instances where women candidates have succeeded, have won the election, securing vote more than their male counterparts as open candidate. On this premise, it is urged, number one, ABCD could do. A, the co-option should be from amongst the contesting women candidates. Who have secured the highest votes, though they could not be elected. Or the discussion of co-option should be left to the state bar councils. Or such co-option should be allowed to be made by the Bar Council of India. ये ABCD चला है T. The exercise of co-option be allowed to be done by the state election committees. Next paragraph. These are all suggestions. Each option has its own merits and demerits. It seems to us that since the supervisory committee headed by Justice Sudhanshu Dhulia is well equipped with the facts and circumstances and have direct assistance from all stakeholders. It seems to us that the supervisory committee headed by Justice Sudhanshu Dhulia is well equipped to take a final call in this regard. It goes without saying that the stakeholders like the petitioners from a state bar councils, from a Bar Council of India, or the contested, the women candidates who are in fray in different states, or other women candidate advocates, might be the direct stakeholders whose assistance to the supervisory committee will be helpful in taking a transparent and objective decision.
Your Lordship.
We therefore dispose of this petition at this stage with a request to Justice Sudhanshu Dhulia, with a request to the Puranam Legal Committee to take a final call, to take to issue appropriate, to pass an appropriate order with respect to the manner in which the option exercise shall take place. Requested above, the Bar Council of India, State Bar Council,
Your Lordship.
and other stakeholders may be heard before passing the.
My suggestion about the Advocate General being associated, Your Lordship could record that, leave it to the committee if they wish to. Because the only problem is who they will associate for each state when they are making the decision regarding cooperation.
That state election committee?
No, the election committee of each state.
That may have been disbanded the moment the election
Once
was
the
over.
elections are completed. I thought because he's a nominated member, he's a member of the.
But as for a petitioners, we have already said that you are the direct stakeholder.
Yeah, well, to be fair, I am an intervener in his.
I am minutes. I
My-
was given liberty minutes so that to go and represent.
That's good.
Yeah,
Yes.
repeat petition. Your Lordship.
Grateful.
My intervention may be allowed so that I have. that.
Hold on.
Yeah,
Your
I'm
Lordship.
great.
Grateful minutes.
Your Lordship, we seek the co-opted members to be elected from the minorities. We only seek the co-opted members to be elected from the minorities who are elected from the.
Unless in these matters, another intervention application was filed contending that when it comes to women, there is a provision given. Let it be extended to the minority community also. That's what their contention is.
But that is not the issue in the main judgment. For that, you can always claim. We have no difficulty.
There's no reservation. It's only representation for women.
That can also go to the committee because
The
should not fix.
as to I is disposed of with liberty to the
Liberty
applicants
may
to
be
approach
granted.
the High Power so committee.
Well, let's say it expands the scope and it's unwieldy because once that is there, then all other sectors will come into picture. SC/ST reservation should be there. Something else will be there. Because my lords have confined only women should be given sufficient representation. It has never been meant to be a reservation.
It's not unnecessarily this issue because this is only confined to women. You can separately file.
That's my humble submission. Great. Deep.
Yes, item 24. Item 24.
Yes, Lordship. Lordship, the subject land appertains to the major settlement plot number 1038, Lordship, which is a jungle kisam land, Lordship. Kindly see the annexure P1 at page.
Who is the contractor who has financed and funded this BIL?
Yes. No, no, Lordship, it's not a PIL, it's a Lordship, writ petition.
What else it is? What is your concern, Adurai?
Lordship, my concern is that, Lordship, the land has never been de-reserved, nor converted, nor diverted for the non-forest use.
When this entire construction was being raised, almost 3 crore rupees have been spent. Where were you at that time?
No, Lordship, the construction has been started and they have published the auction for on dated 13th of February 2026 and 23 March 2026, Lordship.
Want to argue before the High Court. No case to entertain this social petition without dispute.
Prevention is better than cure, my lord. And this petition.
So, Father, your suggestion is very good, but then at this juncture, what?
No, I understand, my lord. This is not possible in this election, my lord. But definitely, my lord, at least. So, my humble request is, my lord, this finger and iris biometric identification, my lord, will not only prevent the bribery, undue influence, personation, duplicate voting, ghost voting, my lord, proxy voting, my lord, but also, my lord.
We are passing a brief reasoned order.
My lord.
Directing the Election Commission there to examine this aspect because it will require a major change in the rules and it might require a huge financial burden also.
My lord, under section 23 subclass 4 of the Representation of People Act 1950, ECI has the plenary power, my lord, to introduce it. Right? What is happening, my lord?
No, power is not the issue.
Yes, my lord.
Power must be there. Power in any case, anything which is for the fairness of the election, that power should always be traced out. There is no difficulty of power. Power we can also direct them.
My humble request is, my lord, because the only ECI is not party. States have to support and states have to provide some infrastructure. That's why notice is necessary in this matter, my lord. I'm not saying in this five state assemblies, but it will definitely, my lord, next year to 2027 election.
No, if the election,
and the states has to.
There are two stages. Once the Election Commission of India takes a decision,
My lord.
and if they find that the state are not supporting, then someone comes to us and tell that yes.
My lord, not only the, in fact, finance ministry has to allocate some budget, etc. My lord.
So
that's why.
If the Election Commission of India will demand and the finance ministry creates problem, then only question of our intervention will come.
My lord, this is not adversarial petition, my lord, it will help.
We know that.
So I'm only requesting lots of issue notice, my lord. Not for this, these elections.
See, issuing notice at this juncture is something.
No, I'm saying, my lord, at most request, my lord, this is not only for this election, these 5 states, I'm not saying that. Lordship may record that also. This is practically not possible in these elections, my lord. Because there are other stakeholders also, that's why notice is necessary in this matter, my lord.
So the issue raised in the instance of petition, filed in public interest. Can have time of the side. Also like this. The issue raised in the instance of petition. In the very nature of things, cannot be given effect, cannot be considered for the ensuing elections in some of these states. However, whether such a recourse deserves to be followed before the next parliamentary election and or in future elections of the state legislature, comma, we need to be examined. Issue notice is honorable for that.
Obliged by it. Obliged. Highly obliged.
May it please your lordships. The petitioner herein is the president of Bilaspur, Himachal Pradesh Bar Association, your lordships. My lordships may have page 190 for a moment. Now, I filed my nomination. Elections is on the 20th. I've already filed my nomination. Elections on the 20th, your lordships.
Rejected.
No, Lord, my nomination was primarily rejected in spite of there being specific orders by your lordships. My lordships, my page 190 and 189 as far as West Bengal is concerned. Similar issue arose over there, where within a week's time at page 190, your lordships had actually directed the Bar Council to actually come up with that amendment that's there. And the notification was issued 1 month later.
They amended it.
They've not amended it. My difficulty is, okay, including, okay, the supervisory committee says that, yes, okay, that has to be done, but okay, there is no approval as of now. My difficulty is, as of now, my tenure ends. Now, neither I can contest for the presidential election is also to be held. I am not the fact that to contest for the Bar Council election, I have not been filed my nominations for that.
Advisory committee has permitted you to contest the.
No, it is not. I'm agree by that order. That's the reason I'm before your lordships. My lordships may have page 190 for a moment. In fact, your lordship's order of 19th February.
It says the council is to amend the rules.
Please, lordships.
They have not amended it.
189, a similar situation arose in West Bengal, where in fact they've clarified that. 189, your lordships, Annexure P8.
Your nominations were rejected way back on 26th March. Now you are coming.
No, nomination is just on 23rd March.
23rd March, it's been rejected, your lordships.
Then I went to the High Court committee.
As per the procedure, I went to the High Powered Committee, then the Supervisory Committee, your lordships.
Election is scheduled on 20th.
Election is scheduled to be on the 20th. If your lordships were to permit me, I can still contest for the elections as of now. And in fact, the Bar Council of India also say.
Rule is to be notified by whom?
Please, lordships.
This amended rule.
They say that they moved an IA which is pending, your lordships. In fact, there's a reference of that. IA number 111-739.
It's mentioned in the order of the supervisory committee.
Yeah, that's at page 9.
It says governed by the 2023 rules. Permitted to participate.
My lordships may permit me in the meantime, because I have only 7 days left. Now, 20th is the election. Now, 20th of this month is the election. I'll otherwise, okay, it will be a futile exercise as far as I'm concerned, your lordship.
Actually, so.
We can't accept your nomination like this.
My lordship, the only sole reason for my rejection is because that I hold the post of a president itself. They rely upon up to 2000 rule of 2013, which has been subsequently amended in 2023.
For the next Monday, you can say.
My lordships, if your lordships can have it to say, we'll have it. If it can be listed Friday, your lordships. If the matter can be taken up on Wednesday, your lordships.
No. We're not saying no.
Constitution bench. My lordships, Friday is fine, your lordships. Otherwise, 20th is the election.
Friday, there is a constitution bench now. That is the problem. Before Monday, there is no hearing. Monday.
My lordship, Monday would be the elections. My difficulty is that.
Whatever it will be, now it is your fate.
The moral code of.
27.
Please, lordships.
Next Monday. For the state.
Notice in Dusty.
Item 27, my lord.
My lordship, I have it top of one second. If it can be listed top of the board, your lordships.
Monday, you can point out what is top or.
If they permit, at least to say, I can contest the election.
Yes, item 27.
Lord, item 27, it's a classic case where operation is successful, patient is dead. Lord, 16th of March, my lord, I approached the High Court, challenging my rejection of technical bid. 18th of March is, my lord, the bids accepted. That is a finding by the learned single judge. The learned single judge also finds that I was eligible. I have been wrongly excluded. And I'm L1 on, my lord, financial bid. However, the contract has been given to now L1 to L3 in a proportion. So the single judge, my lord, the order of single judge is not in challenge before the DB by the Election Commission of India. So the findings have been accepted. Finding is that I'm eligible. The learned single judge only says that, all right, now the bus has left the station. Now you can claim damages. You have been wronged by Election Commission of India, but you can claim damages. That is the finding of the learned single judge. Lord, what I humbly submit, but the finding in para 58 and 59.
So close every arrangement.
No, my lord, the only prayer, my lord, I bow down, my lord. The only prayer I'm making is, my lord, the last election is 29th. If, my lord, may kindly see at page 11, a lot of work is to be done starting, my lord, at 10 days before.
Somebody, one will do.
No, my lord, what I'm praying is, because three parties, my lord, the only humble prayer for my lord's consideration is, three parties have been given this work in share. I could be added as a fourth party. And, my lord, lot of work remains, which is yet to start.
Will not disturb now at this stage. You have been well protected by the, you can have.
This suit for damages, my lord, against Election Commission of India, my lord knows the fate. And I have been unfairly excluded. That is a finding.
The view appears to be, this is a possible view that you have only one small Dadra Nagar Haveli, some kind
Lord,
of.
only one. Lord, Pondicherry has been accepted. Delhi has been accepted. Single judge says Delhi is continue to be UT.
Forget about UT, they have legislative assemblies. Dadra, Nagar Haveli, Neegar, Daman, Diu have legislative assemblies.
But in any case, Election Commission, that order is not under challenge by the Election Commission.
In fact, we have challenged.
In an appeal by a party, the other party can always put into question a finding.
That's right.
You can't ask for a.
No, Lord, in the
Definitely
first schedule to the Constitution, Delhi continues to be a UT, and you can't discriminate between one UT and the other.
UT or not a UT, it's a question of a legislative assembly.
The qualification in clause 4B is saying 3 states. Delhi has been considered to be a state.
Because it has an assembly akin to a
And
state.
Pondicherry has been considered to be a state. And for that reason, learned single judge.
In matters of tender, the interpretation of a clause, first priority and the prerogative of the tendering authority.
That's right.
We interfere only when it is so obnoxious.
That's right.
That
I bow down.
it's our conscience. On the contrary, in this case, we find a logical trend. So why do we interfere?
Well, in fact, even the division bench has not found anything wrong in the detailed interim order passed.
Nobody is saying that you are not competent, but the terms on which they have chosen does not appear to militate against arbitrariness.
It was only, they said states, and the UTs have been considered at par with states.
Great. Logical.
Deeply
Next 28.
May it please your lordships. My lords, the pivotal issue, and that's, my lord, a very vital one. Already, my lord, an investigation under PMLA and ECIR is registered. That ECIR is pending. The ED, my lord, thinks that it is necessary for them for attachment of, say, a project like MB Valley, which has been stayed by your lordships, to seek permission. They come, my lord, and seek permission of your lordships. The application remains pending. The matter rests there. And, my lord, after 5 years, another ED, my lord, over a subject matter which actually arose from a 52,000 rupee dispute, registers another ECIR in Calcutta now, changes the forum jurisdiction, does not discuss that the matters are pending here, goes for a rampage, my lord, search, seizure and attachment of the same property, which your lordships have said no court in India will deal with, and that there is a complete attachment. No other authority will come into the picture. This, my lord, vital issue was raised, whether there could be second ECIR over the same subject matter. One ECIR in Bombay already exists. The, my lord, with utmost respect, the Honorable Single Judge, my lord, notes the contention but does not deal with it. If your lordships can just have few paragraphs of his judgment. My lord, please turn to my lord. The contention specifically raised in this regard about second ECIR noted, but my lord, no answer. At page 40, my lord.
Paragraph are you pointing out?
Para 40, your lordships would see.
Yes, it was submitted that, we have submitted that.
Yes, ma'am. It's been submitted that there can be no second FIR, no fresh investment, or in fact, a prayer before, my lord. Page para 39, your lordship. A page before.
Yes.
The learned counsel submitted that although it has been held in Vijay Madan Lal that ECR is not an FIR, yet the principle applicable to FIR, that only the FIR of a commission of a cognizable offence can be registered, and investigation shall be instituted thereon, and no second report of the commission of offence can be
Your
registered.
argument before the High Court was not on the second ECIR, but on a second FIR in respect of the predicate offence.
I must
Because
clarify,
the
my lord.
ECIR referred to an predicate offence where a closure report had been filed.
Correct. My lord, that's one of.
It was rebutted by the High Court by saying, apart from that, referred to FIR, there are no less than 58 FIRs.
Correct, my lord.
Against this company.
Allow me now, my lord, read
There is a lack of jurisdiction.
para 38 first, my lord. Para 38 at page 90. The counsel for the petitioner has drawn attention of this court. My lord, I have to say two things, and only allow me just about a minute, my lord. The issue today, my lord, is not of, my lord, subsequent FIRs on merging, addition, that also is pending before my lords. Whether, my lord, one ECIR can add other. The question today is, my lord, of two ECIRs over the same subject matter. The first ECIR covers everything, whether the second could be registered. There were, my lord, other issues as well. But, my lord, to this specific issue, allow me to read from para 38, my lord, because this has not been decided. And therefore, my lord, it goes to the root of the matter. 5 orders passed by your lordships, my lord. In Sahara matter, there is every proceeding state in this country. There is a special, my lord, committee appointed earlier, my lord. There was my lord Justice R. Subhash Reddy. Therefore, my lord.
We know that.
Please have a look at para 38 onwards.
Nothing to do with this case.
My lord, para 38, I am not, my lord, saying. I am all on the issue, my lord, whether there could be 2 ED investigations over the same subject matter. Or, my lord, there could be, without disclosing that there is a first ECIR pending, the matter is sub judice before your lordships. ED has filed an IA. If I can read that IA for a moment, my lord. Please turn to, my lord, that IA, which your lordship will see at P2. At P2, my lord, at page 79. Just have a look at P2 at page 79, my lord. This is their IA. The ED is IA before this court. See para 9, my lord, at page 97. Just have a look at that, my lord. It says, pertinent to mention that the Honorable Supreme Court, with the order dated 21/11/2013, had put a caveat on disposal of the assets of the group companies. In this regard, kind attention is drawn to so and so. Now, please turn to paragraph, my lord, 12, at, my lord, page 101. In view of the above, since the matter is sub judice before this honorable court, the applicant, which is ED, considers it appropriate to approach this honorable court for apprising and seeking permission of this honorable court for issuance of provisional attachment order in respect of the properties involved mentioned in the enclosed schedule. The schedule included Ambi Valley property and all other properties. This, my lord, permission is pending since 2017 before my lords. They abandoned their IA. It is listed. It is marked that none appears for them also in one of the dates of hearing. My lord, P9 is that order. But, my lord, simultaneously, 23, 2023, they registered another ECIR, and in 24, they have attached the same very property, which is the subject matter before this honorable court. If this is not overreach, my lord, it could not be a better case. So the issue today is, my lord, and very unique one, which has to be addressed by your lordship, my lord, one way or the other. Could there be, my lord, two ECIRs over the same subject matter and encompassing all, my lord, properties of Sahara Group? There has been one which covers everything. Could there be another? The second is, my lord, adjunct to the issue which is pending. We are arguing, my lord, from the petitioner side, their cases, that, my lord, multiple FIRs cannot be subsumed and merged into one ECIR. That's an issue pending, my lord. I was not arguing on that issue, my lord, before the High Court. The High Court issue was whether there could be two ECIRs. There may be, my lord, several scheduled offences. If they have the power to subsume and merge, they could easily merge with the first criminal complaint which was filed by the SEBI, which is the subject matter of scheduled offence in the first ECIR. So where was the question of registering another? And that too, my lord, all attachments made without reference to all these proceedings which have taken place. Whether, my lord, this amounted to, my lord, selective material being taken into consideration, or, my lord, omission of the vital material, your lordships have lit.
There was no injunction upon ED to attach other properties which are proceeds of.
My lord, there's no dispute about that. I'm not saying that.
So what is the scope of the other proceeding pending?
My lord, your lordships have granted complete.
With regard to the disbursement of the funds and the assets of the company
My lord,
amongst the people,
your
who are
lordships,
home buyers in the Ambi Valley.
I'm very grateful, my lord. Please have a look at your order dated, my lord, November 2013, where your lordship said MB Valley project estate, 7th February 2018, page 108. Just have a look at that one. Just have a look at the order, my lord. I think I'll bring home that point, page 108 P4. And just see, my lord, the operative portion there. That, my lord, serial number Roman 8 at page 115. 115. As this court is in ceasing of the matter, no other court, the country shall entertain any litigation pertaining to Ambi Valley City. And before that, my lord, Ambi Valley City assets, my lord, completely, my lord, should be attached and ordered accordingly 6/2/2017, page 103. Page 103 for a moment, my lord. Your lordships have directed the attachment of those assets. They're already attached.
These are not Ambi Valley City assets directly. These are assets which, according to ED, were proceeds of crime pursuant to the alleged scheduled offences committed by Ambi Valley and its group companies and its directors. These are assets which were placed, layered in other juristic entities.
Correct, my lords. I am on something else, my lord.
Understand your submission with regard to second
ECIR. My lord, allow me just 1 second there so that I can make it good. Ambi Valley City, the ED1, ED number 1 wanted to attach, come to your lordships for permission.
Sir, you would face with your second ECIR argument is Vijay Madanlal Chaudhary, unless clarified, does not put ECIR on par with the first information.
That's right, my lord. I'm saying two investigations. Let me not say ECIR.
Difficulty, what happens
my lord.
is, so in this situation, we cannot apply the ratios of the Supreme Court with regard to multiple FIRs. They are more administrative actions.
Correct, my lord. That's precisely I'm saying.
Rules governing the various units of enforcement directive.
Please, your lord.
That give rise to a legal right on a person who is being inquired into.
My lord, I am.
It is between, let us say, the Mumbai Department of EC with the Kolkata Department of EC.
And both leading to prosecutions.
No prosecution has been launched till now.
My lord, launched in the second case. In Calcutta, launched.
What is a complaint has been filed?
Yes, my lord. That's what I'm saying.
A complaint has been filed?
Yes, my lord. Complaint. And people have been arrested.
Arrest is not complaint.
My lord, complaint filed. PC filed.
If complaint is filed,
yes, my lord,
the Bombay case stands transferred to Calcutta. That's all.
My lord, that's
it subsumes
lord,
in the Calcutta.
Issue of complexity arises. Allow me just
say your difficulty lies there.
Just 5 seconds more, my lord.
Unless the.
Now your lordship says,
CCI
my
has
lord,
come.
just 5 seconds more, my
1.4
lord.
lakh crore.
Have a look at, my lord,
1.4
the,
lakh crore
my lord, just allow me, it's a very vital issue. It will govern, my lord, many other cases.
It has become an
So
issue
allow,
now everything is being questioned.
my lord, please have a look at the provisional attachment order passed by the second ED now.
That can be
At page,
challenged. That
just
can be
see one line. Allow me, my lord, I'll have satisfaction, not like Alice in Wonder. I wanted to say something. The same MB Valley has been attached by them in 2025.
See there when we are looking for investors' interest, not your interest there.
My lord, everybody's interest is prejudiced. If ED, my lord, if ED takes over everything, even your lordship's orders, it would be, my lord, it's not about me. It's about, my lord, the principle of law. My lord, they can't be above the law. They can't do anything and get away with that. They can't conceal facts before, my lord, every court, every forum, in every order. They do not even make reference to Supreme Court proceedings. Whether they are relevant or not relevant, my lord, is a separate question. But when your lordship say this property is attached, why should, my lord, they go and register a second ECIR to attach that?
Thank you. Thank you. Item 50.
My lord, then I'll make an alternate request, my lord.
No.
Only one alternate request, which is very vital, my lord. My lord, all these submissions, what I'm making, let me make at a relevant time, because, my lord, there is now a prosecution complaint filed. My lord, make the issues open so that I can raise them, my lord. These are cursory, my lord, glances by the High Court. My lord, I'll not press this SLP with liberty to raise at an appropriate stage. That's all. I'm saying only that. That much your lordships may allow, my lord.
No. Then again, these arguments are there. You will never allow the things to move in the right direction. That is the whole problem in this country.
No, my lord, if I have an issue, I must argue it.
Yes.
I must thrash it, my lord. So give me that much of liberty, my lord.
Item 54 now, please.
Let's the joint venture agreement in June 2017 actually describes the shares, man.
The argument before the arbitration now.
The problem is that it's a partition issue. Lordship may just see the petition which has been filed before the High Court also. It very categorically says that the dispute is between inter parties. How am I be there in the arbitration? Why should I be there at all?
What precisely you will argue before the arbitration?
But let's see page 34, Mala. Just want to satisfy, Mala. Just see page 33 and 34, Mala. The shares of the parties have been determined. I am entitled only for 62.5%, and the original landowners are entitled for 37.5%. 2017, my lord, now the entire development.
Thank you. No case to interfere with the involved.
This matter can be taken up at 2:30, my lord, together. We'll have a comprehensive hearing at 2:30. Yes. It can be taken up.
All this kind of repetition are maintained.
Lord, I'll answer on all questions if your lordship. If you not, I can answer them now, my lord, or at 2:30. I can answer all questions now or at 2:30.
No, why should we hear it? Where's the question of answer?
No, my lord. Why your lordship hearing the matter? Yes.
Yes, please argue.
Yes. So your lordship may kindly see, my lord, that if your lordship may kindly see, my lord, the first order, page 95, my lord, of this court, my lord.
Have you filed any appeal?
Yes, my lord.
Then go on before the appeal. Today we have got the report.
So that's what I'm saying, Lord. That's what I'm saying. Lord, let there be a comprehensive hearing, Lord, or at, Lord, 2:30, since your lordships are hearing it, Lord. Yeah, I cannot, Lord, ask your lordships to, Lord, apply your mind now and then again, Lord. That's why I said, Lord. At 2:30, if your lordships want, otherwise, Lord.
Every day you become a fashion.
No, my lord. What? See, my lord, if you have a pain over here, my lord, we have come to the highest court. We can't go anywhere else.
Their appeal.
No, I'm not. Then I wish to argue it out, my lord, before your lordship passes any order.
Please argue then.
Yes, lord. So your lordship may kindly see, my lord.
Why should we not look at any document? You have filed the appeal.
The reason is, my lord, I'll give a reason. Your lordship, my lord, will not get angry at the first instance, my lord. Your lordship may kindly hear me, my lord. So your lordship may see, my lord, the first order is, my lord, passed. Effective order is 10/3/2026, my lord. Where your lordships, my lord, said, my lord, kindly have, my lord, page 95.
Please tell us, you have, the judicial officers have not found you to be a valid voter, right? Your names have been excluded. You have gone in appeal. We have constituted the tribunal. Today we have received the report.
Yes,
Today we have received the report that tribunals are functioning right from today morning.
What I'm saying is this.
So what you want to argue for?
Because Mr. Naidu said, my lord, that 9th is the freezing date, my lord. I will not be heard after that. If I'm going to be heard today, my lord.
Your appeal is allowed, and if they don't include, then come to us.
So, my lord, are the appeals being heard today, my lord? Is my question, my lord, to the ECI.
Well, you can't blackmail the tribunals like this.
Doing that, my lord, your lordship, the first, my lord, I have not even placed my case, my lord. I have not even placed my case, my lord.
You have filed your.
My lord, today, your lordship, my lord, at the first instance sent me, my lord, to Justice Sivagana. Now, that order, the substratum of that order, my lord, is three-phased. The first is, my lord, those who are having. No, my lord, I'm explaining.
They have resolved their MOP that has been circulated. Yesterday, they have got all the judges on the appellate tribunal. They have learned how to deal with on the online appeals. That training has been completed. The Chief Justice of the High Court has informed us officially that today they have started hearing the appeal. If you have an urgency in your appeal, go and make out a case.
My lord, we are there, my lord. The only problem is, my lord, I'll be very.
Only because your clients can afford to come via Supreme Court. Therefore, we should ignore the other appeal.
No, I can't, my lord, I argue like this, my lord. Then there's no point, my lord. Then I leave it just like that, my lord. If I'm not allowed to argue also, my lord, then what's the point, my lord?
No question of argument.
My lord, the thing is, my lord, your lordship may kindly say, my lord. My lord, your lordship may kindly say. 9th, Mr. Naidu, my lord, says, my lord, that all the list has frozen. Is the list frozen?
Not the final
authority. My lord, he doesn't even place the matters. The election commission doesn't even place the matters before Justice Sivaganam. Your lordship may see the order, what they do. Just pass the order. They don't even place the orders. They don't know what is happening. The ECI doesn't know what is happening. They don't place it before the court. Your lordship.
What's that concern about them? You go.
So because they are supposed to have all the documents.
Somebody without any basis.
Former Chief Justice of the High Court, the appellate tribunal. Why don't you go and argue your appeal there?
My lord, the reason is, my lord, that the freezing date, they say, is 9. If they make a statement today, my lord, that all appeals are going to be heard, I am not going to come here.
You go there, you argue this,
I am there, my lord, it's not being taken up. There is a practical difficulty, I'm saying, before this court with very folded hands, my lord. There is a practical difficulty. The people are lined up, my lord, the appeals are not being heard, and he says the freezing date is on the 9th. Let the freezing date be extended. That's what I'm saying.
That cannot.
They are nobody to decide it. That will be decided either by the appellate tribunal, or if your appeal is allowed, we will decide.
So, my lord, my only request today is, my lord, with folded hands, my lord, and I'm, my lord, requesting with the greatest humility, my lord, will all the appeals who are there, my lord, will they be decided within a given time frame, or will they come beyond the late? That is our request. An honest voter, my lord, who was there, my lord.
Same answer. That do you want us now through a judicial order command these? Thankfully that these former judges, former chief justices have agreed on our request. You want us now put them under pressure to decide how many appeals?
I don't want. What I say is, my lord, the former chief justice, a great respected chief justice of, my lord, the Honorable Supreme Court of the High Court, my lord, has given 3, my lord, categorical findings. A, those who are having Aadhaar, those who are having passport will fall into the judgment of this court. So, my lord, all those who come into that category in one, my lord, in one swing, they will, my lord, immediately be allowed.
That is for the appellate tribunal.
Correct, my lord. Correct.
They have themselves, as we understand from a communique by the Chief Justice of the Calcutta High Court, sat in a conference, worked out the manner in which they are going to dispose of the appeal.
Yes, ma'am.
Now, there is a large number of appeals.
Of course, but there is a practical difficulty.
Today, we are not in a position to say that you dispose of X number of appeals every day.
I don't say that. I don't.
Let us see if the Honorable, the former Chief Justice has passed an order. It is expected that the committee of the tribunals, they will follow the same, or if they have already, they will give their reasons for
sharing with you. They have already.
Yes, particular case, they had ECI chooses. Today, in a particular case, ECI chooses not to place records, or that is to say, not to seriously oppose an application. But there may be cases and cases where ECI feels that they will seriously oppose an application. It has to be left to the granular reality of each and every case.
Before the last date of nomination, whenever anybody came, we volunteered. We have never taken on any technicality. We said that today itself we'll request the Honorable Appellate Forum so that could be disposed of. And he wants to accuse.
If we
because we have helped.
If we pass an innocuous order accepting your claim, look at.
No, I don't mind. I don't want my claim to be adjudicated by this court. I'm so sorry, my lord. If that is the idea, my lord, I take everything back. My only prayer and the only prayer is, my lord, with great respect, my lord, is let, my lord, the appellate tribunal, my lord, hear me within a given time frame so that I'm a mapped voter, my lord, with Aadhaar, with passport. Should I come into the same category?
I
want to
I
come in the
believe
same
there are
category.
30 lakh appeals.
Our earlier order can be the same order so far as your clients are concerned, that one of the tribunals will take up your case and dispose it. But to say that it is to be done by tomorrow or day after tomorrow, in your part, there was one particular case where there was a candidate.
He himself represented millets.
Why we gave that specific time frame is because of section 100 of the Representation of People's Act. Unfair denial of participation as a candidate is a ground to cancel an election. But right to vote will pursue until and unless it is a enormous number of electors. Which under section 100 again does not fall as one of the grounds for cancelling an election.
And
if
voters, as my brother has
my lord-
pointed out, where the again borrow the language of the statute, which can materially affect the election.
Yes, material.
What I'm saying
Not
is,
mere omission.
Very important thing.
if an idea is given, my lord, no.
Consider this, a number of 10%
Yes.
of the electorate does not vote. And the winning margin is more than 10%. What will happen?
Only
Will
academic
the election
exercise.
be set at naught?
Only academic exercise. But suppose margin is 5%.
But margin is 2%. And 15% of the electorate who are mapped would not vote. There may be, we are not expressing any opinion, but definitely we have to apply our minds to that.
Your lordship's main worry would be, my lord, that those who, your lordship's main, your lord,
We are making a very graded approach
of course, my lord.
to ensure
Yes, my lord.
that all the rights,
Yes.
including the fundamental duty of the Election Commission as a constitutional body, are balanced and a fair and impartial exercise is undertaken.
If my lord,
Not to forget, never keep this in your mind that the concern of a vigilant voter whose name perhaps correctly or incorrectly is not in the list, is not in our minds.
of course it would be, your lordship's, my lord, are men, my lord, men of wisdom, my lord, great, my lord, learning, my lord. Only one thing, my lord, if an idea is given.
The very creation of appellate tribunal is that idea.
Yes, my lord, I know.
To
It
ensure
has been
that
a,
there should be a second.
my lord, it has been a gigantic effort by this court, my lord. This court has leaned over backward, my lord, to ensure that the rights are protected. My lord, my lord,
We're only talking inclusion. There's an objector filing an appeal.
if
An objector filing an appeal
Object-
in respect of an inclusion in the electoral roll as per the recommendation of the judicial officer. If that is also allowed, then that person has to be removed from the electoral roll.
But today, my lord,
They have
what-
done it. There is another putty. That's our worry. There is another.
it has been, my lord, quite taxing on this court, my lord, because of the time frame. My lord, I fully appreciate your lordship. My lord has done a
This
great
is
effort by
the-
700, my lord,
It is
judicial.
the judicial officers and now the appellate.
Yes, my lords.
So, my lord.
My lords may
only-
recollect, my lords.
Only two
Initially,
submissions.
your
my lord.
lordships were not even inclined to have an appellate tribunal,
Only two submissions.
saying that one, since the judicial officers have been exercising the power granted by your lordship, that should be the one, nobody should sit in appeal. Then my lords have relaxed it, that one, said that let there be an appellate forum. And these people have their remedies there.
Very vital questions involved, right?
Yes, my lords.
See, we have permitted the constitutional authority with its concern of purity of electoral roll to go into inquisitorial exercise.
Yes, my lords.
If you see the original SIR notice, it talks of the benchmark as 2002 electoral roll.
Yes.
So the SIR that had comments does not touch a person who is in 2002.
Yes, my lords.
But when you flag logical discrepancy, you in fact touch that 2002 electoral roll.
My lords, what we have said is anybody who has been there in that one, they are automatically in.
But then the logic,
Provided, my lords, provided they can put their credentials and track this thing without any discrepancy.
sir,
Yes, my lords, with great respect, I can demonstrate.
2000, if you
Yes, my lords. Yes,
will examine it definitely.
indeed.
But
Yes.
we can tell you the way we read the 2002, your notification, a 2002 electoral roll is fixed. It is not touched. What is touched is people who are relating them to the 2002 roll, like a son whose father is there. He relates to 2002 roll through what? Through a passport, through any other document. 2002 roll is the benchmark. Why? Last election intensive is that. In the logical discrepancy list, and that is why in your final list that you published, you did not delete them.
Well, let's make absolutely, there's no question of any deletion.
Not delete
Every person has to submit a form
sir,
where they have to establish that it's one and the same person.
Please again examine your
Yes, ma'am.
notification.
I will.
I
will examine.
2002 entered voter does not require to give anything. And that was the submission. You were not present.
He has to give a form
Mr. Naidu,
affirming that he is the same person.
when the Bihar SIR was argued,
Yes, ma'am.
and we understand Bihar SIR is a facsimile of the SIR that we are dealing today, because that's a common SIR. The submission was very clear.
The only difference is.
Well, it's the same form, the same method, nothing has been changed.
That is
And
so.
what we have said is that,
That's so the submission from ECI was unequivocal.
Yes.
A person in the 2002 electoral roll does not require to give anything.
Millets, he need not prove anything further. Only thing, he is the same person. For that purpose, we have given two columns. The column which reflects 2002 name and the present credentials. If they match, automatically is in. In most of the cases, Millets, unfortunately, they have not taken care to put the correct particulars. They've invited the trouble.
If that is so, please examine the written submissions put in the Bihar SIR
We will.
case.
We will.
It is very clear.
Millets, I take it and I'll just
Not
come back
that
to your
the
lordships.
entire electorate has to upload documents. No.
Millets, no document is needed provided you are there in 2002. Those who have, yes.
Now you are
Millets,
amending your
I'll just demonstrate in one case,
You are
Millets.
deviating from your original
No,
document.
Millets, what has happened, in 2002, somebody is else there. And they have to replicate whatever was there in that one. And they,
Let's not, you are only trying to say that somebody says today that how I will excluded my name, I am there in the 2002 list. You are saying, sir, if you are there in 2002, you are welcome. But in 2002, the name is XYZ. Today you are claiming XYL.
Exactly.
Therefore, the problem is right. XYZ.
that's the only discrepancy. Had they faithfully filled the forms cautiously that the same person, they wouldn't have been, automatically they would have been allowed. What they have said is, that's my alias name.
A 2002 elector does not fill any form.
Millets, They need 2 minutes. Enumeration form is a mandatory one. Form, all that they have to do is, may I just give the practical ones which we have done, millets? I'll show them to your lordship.
They just
So that
fill
my
up-
lords could
they
appreciate.
fill up their names.
Yes.
That is it. No
Exactly. It's a ministerial job of filling up the names correctly. If they have not done that,
That is only an format without any documents. That there you disclose that, yes, I am there already in
Yes.
2002, I am not required to,
I am not required
not
to put in any confirmatory document.
yes, not necessary at all.
Document is
That
for
name itself is
candidate.
enough.
Yes, now
Only
you
thing
are
is,
correct.
the details should match. There ends the matter.
Now what?
I'll just submit a model forms to your lordships. Kindly consider them. Whether there is any
You are
deviation.
submitting model form to someone who has filled up a form.
Beg your lordship's pardon.
You are submitting model form at least to me who has filled up a form. All right.
No, Minister. Where the cases where they have not matched, despite their being there in 2002, once they have made a mistake in presenting the present enumeration form, that flags. Otherwise, it's in.
That is not only the filter used in flagging logical discrepancy. There are multiple filters.
Millets.
There are multiple filters like, let us say I am person A,
Yes, Millets.
son of person B.
Yes, Millets.
My name and father's name matches. But there is a filter that there is another person by the name of C, whose father name is B, that's the same, and they are born within 6 months. That sort of filters are
That's
there.
what we have called logical discrepancy, Millets. That's what we have called logical
That is what
discrepancy.
I am bringing you.
Yes.
When you bring in this logical discrepancy, it actually invokes your constitutional powers of verification, right? That can never be taken away. It is there.
Yes.
And what you rely on, in our understanding, is Section 22 of the Representation of People's Act. That is a suo motu inquiry.
Yes.
And when you go into suo motu inquiry, Mr. Naidu, you examine Rule 19 to Rule 23 of the Registration of Electoral Rules.
Yes, Millets.
They require a hearing upon notice. In this situation, what happened was there was no hearing given. It was only a verification.
Millets.
Of
After that,
documents submitted. That is why we are coming to this. Why we wanted the appellate tribunal when there was a constriction at the first instance verification. We need to protect the due process rights.
May I just submit one thing, Millets? Once we have published the list of logical discrepancies, whatever the variations, Millets, and then based on that one, they're informed, then they can as well submit to the ERO their objections or their justification, how in that process, my lords have said, because of the inadequacy of officers, judicial officers have come into picture.
Been done because the volume of logical discrepancies which were marked and the date for the election was so close, and there was a constitutional issue of trust deficit, which we pointed out, between the people given by the state, inadequate, not literate with regard to the...
The whole issue began there when we wanted adequate manpower, trained ones, that has not been provided.
In this situation, we had to evolve a process. The process, however, had certain departures from Rule 1920. Because 1920, when you see an inquiry, it speaks of a notice, the opportunity of hearing, and opportunity of presentation of documents, hearing being discretionary on the election officer. We could not give hearing wherever necessary by the judicial officers. So we have to leave this open for the appellate tribunal. And that is why our request to both of you, we cannot hurry this process.
Well, as far as the year was concerned, there were hearings happening. Then judicial officers have come. Kindly see, Millets, the justification of logical discrepancy. To this day, after the scrutiny of judicial officers, 47% is the rejection.
Not on the...
Because they have been justified.
Not on the end justifying means. We are on the means, subjecting themselves to the reasonableness and fairness.
Could my lords recollect, Millets? The whole trouble began When we wanted EROs who have had this quasi-judicial experience, they were not provided. Once we have taken,
Mr. Naidu, it is not a fight between the state and the election commission.
inadequacy of manpower, my lords, I'm submitting.
It's not a blame game. It's a question of the voter being sandwiched between constitutional entities.
My lords, we have given every
When-
provision,
when-
we have given every assistance.
When we are fully in agreement with you.
Yes, my lords.
From your point of view, you have put your best foot forward. From the state's point of view, they are circumspect. We have decided that in this situation, to ensure a fair and impartial election, the purpose of the court must be enabling and not a adjudicatory exercise of who is right and who is wrong.
My lords, in the orders also, your lordships have chosen the votes very carefully in a very balanced manner, never an accusing finger, either side.
The very spirit of court's hands-off approach, and if you see Mohinder Singh Gill,
Yes, my lords.
Lokhi Kantro Sen,
Yes.
each and every case, the courts have intervened to promote fair election.
My lords, we have had every
Deter
endeavor.
or interdict an election.
Yes, ma'am.
And that is our spirit, which we invoked under Article 140.
Precisely, my lords. Even
Deploy officers where there was a trust deficit between the state and the constitutional entity responsible for superintendence of roads, that these judicial officers will undertake a verification. But the volume, because we were not able to give the adequate numbers, the volume at which they had to do, there is always a chance of error. Just consider, Mr. Naidu.
Yes, my lords. Could my lords?
Going through 1,000 documents a day, if our correction or accurate rate is 70%, at least speaking for myself, I will rate the activity excellent.
Excellent.
So this is the pressure at which the judicial officers have worked. And so there will always be a margin of error. And in these situations, again, tested from the principles of reasonableness, due process, we need to have a robust appellate.
Yes, my lords.
We need to have a robust appellate program where both parties
May I add only one thing, my
can
lords?
ventilate and have a continuing right.
Yes.
Somewhere we are getting blinded by the dust and fury of an impending election. But a
Well, it's-
right to remain on a roll, a right to vote in the country where you are born, is something which is not only constitutional, it's sentimental.
Indeed, my lords.
It is the biggest expression of nationality and patriotism that you are in a participatory process
Democracy.
to create and elect a democratic government. So this is something which we need to very zealously.
Precisely, my lords. Precisely. We have given statistics, my lords, involving all states that have been subject to SIR.
Please help.
The exclusion or inclusion, we have given the percentage. West Bengal doesn't stand out in any manner. It's been on a par with many other states. And only question is that, my lords, with regard to manpower, my lords have come to our rescue.
We are not bothered about West Bengal standing out or West Bengal
It's been on a par, my lords. Only question is,
being a common theme.
yes, my lords.
But today, logical discrepancy has not been a category in others. We have examined Bihar and we have found not a single person was flagged on logical.
My lords, West Bihar too has exclusions. Not even a single appeal was filed. What's the percentage of Bihar? The table, you see? Take the table.
How come we missed it? Was there any logical discrepancy? The election council can always manage the problem that they faced. We have 45 deletions, right? How come you are this side? Next one, I think it's okay. 47. Yeah, that's what I'm asking. Give it to the 47 different things we have. Saturday morning, 35,000. Today morning, you can something. Justice Bakchi's thinking that notices and no hearings on logical discrepancy cases, which is not correct. Notices would come issue the hearings happen before the ERs. The fact that the state of defeated making the creation of such scale. The only issue when the hearings did not happen for the creation of. But it's not so that there was no hearing it. It is his right that there may be errors. That's why we are also pointing out that there are errors in their decisions. And we will also point out things. The tribunal should therefore not be heard by such kind of petitioners. That is all that we are saying. What are those people who have assisted us? What are they called? Are they still there?
Yes, they're still against. They have been given assistance to the judicial officers. Now that the job is over, then they have been deployed in the election building.
My lords, may can I state one thing, my lords?
Working the appellate tribunal, it's not a competition of
They have an enormous task now.
Conflating the electoral roll or deflating the electoral roll?
Neither way, minutes.
Ensuring a fair hearing in inclusion and justifying it.
Absolutely. My lords may have seen when there are strange instances, candidates coming over, we have readily volunteered, gone over there and we have done it. With regard to my lords,
Very right and good spirit that.
yes, my lords. Now it seems there are about 25 to 30 lakh appeals to be decided by them. 34 plus, my lords.
On a very arithmetic computation, each tribunal is having over 1 lakh appeals. If each one is.
From day one, my lords, from day one, wherever there is an exclusion or flagging out, we have put them on notice and micro-observers have assisted the EROs and later the judicial officers, and at arriving at the just conclusion, then the orders were passed. Only the issue came with regard to the inadequacy of EROs. Otherwise, it was a smooth keel.
The question of hearing was not there.
Yes.
So in these situations, we may require an online. Tell us what we want.
I'm afraid there was hearing before EROs.
My lords, is hearing the West Bengal SIR matter to.
There was.
There's no use of any academic exercise.
So be it.
So we'll see that how the tribunals work and.
Yes, my lords.
Your
Yes,
lordship is hearing the West Bengal SIR matter to.
If
My
I
lords.
give the order passed by Justice Sivagnanda, my lord, your lordship may kindly read.
We will
paragraph
not
during.
mention any,
I-
which should be very clear because it will.
No, the other matter, my lord, your lordship want me to continue the argument with that, my lord, or should I conclude it here and now?
No, here there is no question of we will not enter.
No, I'm not, if an impression is given, my lord, that I want to score a point and come here first, take an order and run away, that's not the point, my lord.
Still half day working.
Yeah.
Instead of getting an order in the evening,
Yes.
better you pursue your appeal there.
No, I'm not saying
Make
that.
out a case of urgency before the tribunal.
So if your lordships, my lord, are under the impression that I've come here to get an order from your lordship, run and score the match over others, it's not that, my lord. I come here, my lord, to say that, my lord, till the 5th, the venue, my lord, was not established. There's an
indicated to you.
No, so if the ECI comes up and says, my lord, that first, second, we did everything, there is a letter by the registrar, my lord, of the High Court saying the venue is not available.
You are more concentrated on.
No, not. I am now on para 9, then your lordship may see page 103, my lord. They say, my lord, that the judicial officers, my lord, have worked backwards. You see page para 9, my lord, at page 103.
Anybody will try to target the judicial officers. It is not acceptable.
Nobody is targeting anybody.
But once the documents have been scrutinized,
If the documents have not been scrutinized, the High Court Chief Justice says the documents are not scrutinized, there are no reasons given. Kindly see.
It's a wild.
The High Court Chief Justice says that there are no reasons by the judicial officers. Para 9, your lordship's order.
let them pass an order.
So if somebody passes an order saying delete it and without any reasons,
Once the judicial officers have scrutinized the documents, there is a
they
presumption.
have to give reasons. They have not given, the High Court Chief Justice says they are not giving any reason. I fear. He says, I fear it.
Disrespectful like this.
My lord,
They have done a commendable job.
they have not given any reasons. They have brushed everybody's side is my submission.
They have done it.
They could not have done that. The High Court Chief Justice says at para 9, the issue of alleged non-availability of reasons for rejection of the objection by the adjudicating authority, namely the judicial officers, is also highlighted by the learned Chief Justice.
They've been given an
And this is
opportunity
the what
to file an appeal and to vindicate their stand.
in that particular
They've been
matter,
given an
they don't
opportunity.
give the reasons. Just read that order. Read para 9 with what Justice Sivagnanda says.
Since the petitioners have already.
It is very unfortunate.
Before the appellate tribunal, we are, in our considered view, the rest of the apprehensions expressed in this petition are premature. It goes without saying that if the petition's appeal is allowed, the necessary consequences shall follow. If necessary consequences shall follow. The petitioners, if so advised, may therefore approach the appellate tribunal before whom their appeal is listed and make out a case of out of turn hearing. It is explained, we clarified that we have not expressed any opinion on the merits of the case.
That is what they're doing.
Manoj, may I have your.
This is very unfair.
It is not unfair.
May I have your.
Yes. When you are frustrated, you don't have a point. The only thing is showing the lung power and accusing others.
This is the appellate tribunal. Both sides, you produce the documents and reports. We have already mentioned our detailed, despite detailed order. There is no question of now arguing here.
Manoj, I am seeking your lordship's
We are
leave.
coming back. We are coming.
Manoj, I wanted to mention item 59 for Manoj, if your lordships may take it now.
Item?
That 59, this is that unfortunate POXO case, Manoj. And
yes,
the
yes.
difficulty is the commissioner is here and there's some law and order issues, Manoj. which are brewing.
Told in the morning, yes.
Yes, my lord. So would your lordship take
No,
it up
please
now?
go back, we had on it, send them back.
Please, my lord. So commissioner can go back.
The instruction.
I have the instructions. I have the certified
Understood.
copy of the file, my lord. The ACP and SHO will stay. The commissioner may go back.
My lord, before, in that very matter,
Ministers matter Act Civil 46 and 46(1) was specific today at 2 p.m. for final hearing and lodging in the afternoon. It's a foreign award which is passed in my paper about 100 crores of. I have subsequently.
What happened? Abhi tell me, I'll take.
Hey, at 2 p.m., your lordship are busy in the afternoon. But they request 26th of April, it's in the first week of January.
I don't appreciate this kind of interference.
my lord is,